Okay.
Excuse me, Madam Chair, we are live.
Okay, thank you so much. And good afternoon, everyone. Welcome to the special Electoral Area Services Committee for March 18th, 2021. I'd like to acknowledge that we are on the traditional territory of the Coast Salish people, and with that, we'd like an approval of the agenda. Why not? It's been moved and seconded. All in favor? Opposed, if any. Motion's carried. And I'd also like to mention we have a 35-minute presentation by Ms. Cheryl, and we have a director that needs to leave by 3:30. So I'm hoping that we can accomplish this information item and be able to fit in. That needs to leave by 3:30. So I'm hoping that we can accomplish lots of feedback, hearing myself. I don't know if it's stopped now. Anyway, it has stopped. Okay. So with that, I'll turn to Ms. Harrison for the public input. Go ahead, please.
Thank you, Madam Chair. We have 3 participants today, and in order, it is Susan Kaufman, Cliff Evans, and Bernard Yearling.
Welcome, Susan. Go ahead, please.
Good afternoon, Madam Chair and Directors. I would like to thank Ms. Cheryl for the report. It is my understanding that this is for information and Bylaw 4379 will not be up for a vote today. There is a lot to unpack in this report, and it sounds like more reports are forthcoming. I am genuinely concerned that efforts to streamline development processes and corresponding bylaws will come at the expense of the public's ability to participate and have a voice in land use matters, and further diminish the director's ability to represent their electorate. Efficiencies can and should be made without excluding the public. Through the application process, we have learned that some zoning bylaws or DPs do not have authority or reflect the intent of the current OCP. This was also identified in the harmonization process through the review of the OCP zoning bylaws, DPs, and DPAs. Would it not be better to wait until the harmonization and modernization processes are complete to further contemplate additional delegation of authority? By example, you heard yesterday a bylaw amendment application to correct a zoning bylaw that did not reflect the intent to protect a water body, watercourse, or wetland as per the OCP. The delegation of an application for floodplain regulation exemption, phase development agreements, minimum lot frontages, register and amend or discharge a covenant have all garnered strong public response in the past. Why give away what little ability you have to affect subdivision approval when the MOTI is the approving authority, or be reflective of public input? Delegation of heritage alterations or agreements is concerning. As an APC member, it is hoped that the CVRD will commit to engaging the APCs in meaningful ways when contemplating changes to policy. Collectively, we have lost several members due to frustration, a lack of consistency, and consultation. I fully support the CVRD's development approval function by implementing a land management system and development tracking software system. It would be appreciated if the CVRD would consider changes or amendments to public notice and requirements to post a sign. If I have a few minutes left, I could read through them. Public notice that the CVRD will work to amend the current standard of 60-meter notification requirements to include an increase in notification distance for rural properties, to set a standard for GIS when determining notification criteria, to develop a notification process beyond the standard newspaper notice and CVRD website to reflect the modern forms of communication using
I
social
believe
media.
your time is up. Is it
Okay,
Ms.
I-
Harrison? Okay,
Yes, it is, Madam Chair.
okay, thank you. And we go to, who is next?
Mr. Evans, Madam Chair?
Mr. Evans, go ahead, please. You're muted. Still muted. You need to take off, you need to unmute your microphone. We can't hear you.
Okay, can you hear me now?
Yes, we can.
Good to see you, Madam Chair, and everyone else. Madam Chair, draft bylaw 4376, or pardon me, 4379, increases the delegation authority of the general manager to make decisions on all development permits. Where development permit applications comply with the applicable guidelines, the development permit must be issued. I don't really agree with this. These are just guidelines, and there will be variances for every case, and they must be taken into consideration. Madam Chair, bylaw 4379 also gives the authority to the general manager to discharge the benign or redundant covenants and or approve strata conversion of previous occupied buildings. Delegating your authority to let the general manager perform all these functions gives the decision to one person instead of 9. It gives the public, it leaves the public out of this process almost altogether. Much of our forestry land in the Shawnigan watershed has very old covenants on it, and to write off these covenants would be like writing off our watershed. We must be very careful what we do with our covenants, and the directors and the public should have a say on this. Please leave the authority to make these decisions to the board with public input. Thank you very much, Madam Chair.
Thank you. I turn now to Mr. Yearling. Go ahead, please. Welcome. You're muted. I can't hear you. Still can't hear you. I'm not sure if we checked his microphone earlier. Sorry, we're still unable to, it shows that you're unmuted, but I can't hear you. Not sure if the IT, is there anything we can do?
Yeah, he'll have to click the 3 dots on the bottom of his Webex screen there, go up to
Okay.
switch audio or audio settings, and make sure that the mic is set correctly.
So can you see the 3 dots, Mr. Yearling? Okay. See that your microphone is set correctly.
There's also the drop-down arrow beside the mute button at the bottom. You'll be able to see what speakers and what microphone options you have. Should be one that says use system settings or microphone array, depending on what your computer has available for you.
Is any of that helpful to you, Mr. Yearling? No?
An
Okay.
alternate option would be to use the call-in number and call in quickly to.
So we have a call-in number if you want to do that. I don't. Can we send him the call-in number?
He was sent all of that information in an
Oh, okay.
email.
Okay, so, and we have our time. I think he's going to try
7
that.
minutes left.
Okay. So he's doing that. Susan Kaufman could go ahead with a few more minutes while we're waiting for Bernard. While we have a lull, while we have the intermission, if you weren't finished, Susan.
Thank you, Madam Chair.
Until and you might be interrupted if we get Mr. Yearling on ahead. So go ahead, please.
Under public notice, to develop a notification process beyond the standard newspaper notice and CVRD website to reflect modern forms of communication using social media and inclusion of neighborhood associations and groups for expanded reach, to further enhance the CVRD website to be more user-friendly for the public when accessing information on CVRD events, public hearings, public meetings, minutes, and meeting notification. And under the requirement to post a sign, that the CVRD will work to amend the current standard for signs, including sign placement, design, and composition. Thank you.
Thank you. We still have a couple more minutes. I think Ms. Harrison, we're still waiting for Mr. Yearling.
We have 5.5 minutes left.
Okay. We are a little bit of an intermission while we wait. I hear something with somebody. Oh, no.
Mr. Yearling, are you dialing 250-900-4337? Is that what you're dialing?
Oh, there we go. Okay.
Okay, so I gotta mute his.
Okay.
Yeah, I think he has to speak his speakers off. Turn his speakers off.
Okay, is this better?
Yes.
Okay.
Yes, you have it. Go ahead, please. You have a few minutes. Go ahead.
Madam Chair and Directors, I agree with Cliff Evans and Ms. Kaufman that I strongly oppose the proposed amendments to Bylaw 4379. I understand that this will alleviate some of the work of the directors, but it gives too much power to the general manager. So the idea that if all the boxes are filled in an application, the general manager will then have authority to approve a development or discharge a covenant, I think is dangerous. Simply because all the boxes are ticked off doesn't mean that the development will go as proposed. A classic example is with the applicant for the soil permit considered yesterday. In the previous soil deposit permit given, despite the fact that the applicant is supposed to have a qualified engineer overseeing the process, he proceeded to dump waste materials into a soil deposit fill site. So I think it is critical that there's an oversight by the public for many of these applications. Thank you.
Thank you very much.
Okay.
Okay, we can move on. That is everyone for the public input. So we go to reports.
Thank you, Madam Chair. Item R1 is a report from the General Manager, Land Use Services Department regarding development procedures, and this report and PowerPoint presentation is for information.
Okay. Welcome, Ms. Cheryl. Go ahead. Thank you. We can see you're sharing, so it was part of it.
You're muted.
Sorry, I had to unmute myself before I started sharing because it seems to be difficult to unmute yourself after. So this should work now. Okay. Can everybody see my screen? Are you seeing my settings? How's that?
Yeah, but it's two screens. It's got the agenda and development services. So you've got two up. I think it's your note, or there's no notes. Oh, it's just the next slide. Your two slides are showing.
Okay. There we go. How's that?
That's it. You got it.
Perfect. Okay. Technology's our friend, right? So what I'm going to go over today is I'll talk about development services and sort of how things are today. Then I'll talk about the modernization project and proposed bylaw 4379. And then some issues and opportunities, and then we can have a discussion at the end, and I'm sure we'll have a lot to chat about. So development services, there are a range of responsibilities, including the staff respond to inquiries, they review applications, they respond to referrals from other agencies and governments, conduct research and analysis, they prepare permits, bylaws, and reports, and they support the committees and commissions of the board. They also engage with stakeholders, prepare communications. They're required to undertake mandatory professional development. Ideally, in a perfect world, we would spend more time doing public education and outreach. And it's also important to continually review and update our policies and procedures. And of course, that's what we're focused on here today. So the applications that typically come before you include bylaw amendments. So that could be official community plan and zoning bylaw amendments. It could be an amendment to a land use contract or a phased development agreement. I won't talk too much about those things today because that's really not the substance of the presentation. You also deal with land use permits. So development permits, development variance permits, temporary use permits. And then our other applications, covenants, so frontage exemptions in conjunction with subdivision applications, agricultural land commission applications where the board is required to decide whether or not to forward an application to the ALC. And then cannabis retail licenses where the board needs to decide whether or not cannabis retail license should be issued. And then depending on the board's decision, the province will make its decision. If the board says no, then the province will not issue that license. So this is the general framework that we work within. We have at the very top there, the Local Government Act. Some regional districts have adopted a regional growth strategy, which then feeds into the official community plan or official community plans. Obviously, we don't have a regional growth strategy within Cowichan, so you work within the official community plans that have been adopted for the individual electoral areas, and soon we'll have hopefully a harmonized official community plan. Underneath the official community plan, then we have specific regulations. So we have zoning regulations, parking, sign, landscaping regulations. We have development guidelines. So development guidelines can be either in the OCP or they can be in a land use or a zoning bylaw. And then there are other bylaws. So works and services bylaws, parks bylaws, servicing bylaws. Whenever a regional district or a local government municipality has adopted an official community plan, any bylaws that it adopts or works or services that it undertakes must be consistent with the official community plan. At the bottom there, you see permit, the word permit, where a development permit area has been established and development is proposed and a permit is required, an applicant has to provide information to support what they're doing. If what they're doing is consistent with the guidelines, the CBRD is obligated to issue the permit, and that is based in a lot of case law. So that's where that premise comes from. So we also deal with a lot of other legislation. So we have the Agricultural Land Commission Act, the Water Sustainability Act, Strata Property Act, Liquor Control and Licensing Act, the Cannabis Control and Licensing Act. There are a number of others, Public Health Act, Environmental Management Act, I could go on. So this is all stuff that that we're aware of when we're when we're processing an application, we're looking at a lot of different policies and regulations. So the Local Government Act also says that where local government has adopted an OCP or a zoning bylaw, it must define procedures under which an applicant or, sorry, which an owner of land may apply to either amend the plan, the OCP or a bylaw, or to issue a permit. And that refers to, it's talking about a permit under this part, that part being part 14 of the Local Government Act, which deals with land use applications. So those are our development permits, our development variance permits, temporary use permits. And a local government must consider every application for an amendment or the issue of a permit. So despite what might be happening, somebody can apply at any time, and the local government is required to consider that application. So this is the framework that we operate in when we're processing an application. So similar to our sort of our legislative framework for all of our policies and regulations that govern land use, we have policies and legislation that govern how we process applications. So again, at the top, we have the Local Government Act. We might have some board policies which determine what our procedures are going to be, but the procedures and are enshrined or required to be enshrined, like I said, in the Development Procedures Bylaw. And then the LGA also allows for you to establish commissions by bylaw. And those commissions also have rules governing you know, how they work. And so, you know, for instance, one of the things for APCs is that their bylaw is required to include procedures around referrals. So those right now are sitting in your development procedures bylaw. Really, they should be in your APC bylaw. So that trickles down into what we call our standard operating procedures, or SOPs, or just procedures is fine for how we work on a day-to-day basis. On the outsides, it's interesting here to the right, I'm showing again, we have other legislation that might influence how we process an application. So for instance, the Environmental Management Act recently was amended to include a requirement for us to look at site profiles and ensure there are certain uses that haven't occurred on the property before issuing a permit. So that's kind of one example. There are times when we'll issue a permit, but an applicant won't necessarily be able to undertake their use or their business or their development until they've complied with other legislation, and that might include something like a water license that has to be issued by the province. On the left, we've got the official community plan. So the official community plan can designate area where you can obtain development approval information. So designating lands where you can request certain information be provided to support an application. And this was discussed a little bit yesterday. So most of the OCPs, I think, already do that, and it's certainly within the harmonized OCP. We have a development approval information bylaw that we do use from time to time. So that's a bylaw that will be updated as we move through modernization through the community planning division. The development approval information bylaw is also important to inform what the content of our application forms is. So our application forms to specify the information that an applicant needs to provide to support their application. And I'll get into that a little bit more as we move forward. So I wanted to mention also that we also handle a number of different referrals. So these are sort of applications that are handled by other agencies but are sent to us for comment. So liquor licenses, subdivision, road closure, water licenses, telecommunication towers. In all of these cases, those agencies, usually the province, is looking for some comments from the CBRD. And from time to time, this also requires a resolution of the board. So One example I'll draw, and this is a current one, relates to the telecommunications tower proposal in Salem. So TELUS right now is undertaking a consultation process. There's a federally designed consultation process. The CBRD does not have its own, so TELUS uses the default consultation process. At the end of that process, they will come to the CBRD and they will ask the CBRD board for its concurrence on that proposal, and the CBRD board can decide whether or not they want to support that application, and then ultimately the federal government will decide what will happen on that in that case. So moving on to modernization. So like our harmonized OCP process and the work that we're doing in community planning, we're also working to modernize the work of development services. And of course, we completed service review in 2020 that provided a number of recommendations. I did report to the committee on the outcomes of that project recently. There was also a major study that was completed by the province of British Columbia, the Development Approvals Process Review, DAPR. So that information is available on the provincial website. But essentially what it distills down to is direction to local governments to streamline their development processes to support applicants and developers in moving through their processes in order to save time and money for all parties. Obviously, the quality of applications should not be sacrificed, and the quality of the development should be what local governments want it to be. So when we say streamline, we mean streamline in terms of efficiency, but also maintaining quality. So this landed in your strategic plan under the theme of our communities and the strategic objective to create healthy, livable, and efficiently serviced communities. So a number of these actions relate to the harmonized OCP, but 6.3 speaks directly to modernizing the CVRD's development approval function. And as was noted earlier by Ms. Kaufman, there are kind of three things there. So implementing a land management and development tracking software system, enhancing policies and procedures, and supporting advisory planning commissions. And so all of those things are underway. We recently went to the advisory planning commissions and conducted orientation sessions and advised that there would be some work happening, and there would be a report coming forward to Electoral Area Services Committee, which is where we are today, around development procedures, and that we would also be looking to engage with APCs in the development of public consultation policies going forward. So our real objectives under modernization are service delivery efficiency, enhanced consultation and communications with the public, who are the clients of the service, and a better decision framework. So we want it to be easier to process applications and understand clearly what the requirements are going to be, so that the applicants have clear information, the public has clear information, and elected officials have clear information when they're making decisions. So proposed bylaw 4379 is intended to be consistent with the Local Government Act in terms of the scope of the bylaw and the types of applications that will be dealt with underneath it. Delegation is proposed to be expanded, and I'll get into that in a bit. Referrals are intended to move to policy. We have been reviewing the development procedures with our legal counsel, and the suggestion was made that really the bylaw before you should contain what it needs to contain in terms of regulated procedures, so regulations. That doesn't mean that you can't have a robust policy that accompanies the bylaw that assists in the processing of applications and fulfills your wishes around public consultation and consultation with your commissions. Fees would be moved to a fees bylaw, and that's also under development. So this is just a sort of at a glance of the types of applications that are dealt with now under bylaw, your current procedures bylaw 4267, versus what would be handled under bylaw 4379. And you can see there that the Board of applications for Board of Variance decision, that would be moved to the Board of Variance bylaw. File review and subdivision fees can be dealt with under the fees bylaw. Those are not CBRD applications. And just to note, we also have requirements within our current subdivision bylaw, our works and services bylaw around processing of subdivision referrals from the Ministry of Transportation. Minimum parcel frontage waivers are not dealt with under current procedures bylaw, but obviously we are dealing with them, so they need to be addressed under bylaw 4379. And once they're under a new bylaw, we can also charge a fee for processing those applications. And then the others include floodplain regulation exemption. So you'll be having a report coming forward soon on proposed floodplain bylaws. There is provision in the Local Government Act to allow exemptions from those bylaws. So we need to create a mechanism for somebody to apply for an exemption, and that would rest within this bylaw. And then heritage alteration permits and revitalization agreements are not application types that you've dealt with previously. Heritage conservation is certainly contemplated in a number of current official community plans and should be explored through the modernization, the OCP modernization process. But we can also include that in bylaw 4379 in anticipation of those things becoming more important in the future, perhaps. So delegation of authority is authorized under the Local Government Act. And what it says is that subject to the specific limitations and conditions established under this or another act, a board may delegate its powers, duties, and functions. Delegation should be beneficial. So there should be a reason for the delegation, right? So it's streamlining work. It's not resulting in a reduction in the quality of the outcome. It is reducing the amount of administrative or staff time to prepare reports to the board and to prepare presentations to the board, etc. For what would be technical applications. It needs to be based on a trust relationship. So when I say that, I mean the board needs to have faith that the person or persons whom they're entrusting their powers to will do that in a professional manner, that they are accountable to the board and that they're acting in a manner that's responsible. I included some Latin here. This is a really important I may not be saying it correctly, delegatus non poteste delegare. What that means is the delegate, there's no sub-delegation by a delegate. So once power's been delegated, the delegate needs to exercise the authority. They cannot further delegate the power or delegate it back to the board. So once you've delegated, you've delegated. So there are certain powers that cannot be delegated, and that includes the power to authorize a variance. So development variance permit cannot be delegated, and the other is the power to adopt a bylaw. So a zoning amendment bylaw or an OCP amendment bylaw. There are a number of other powers that cannot be delegated that deal with budgets and other financial matters. And I won't get into those because they're really not related to land use planning, but those are the two key ones that you can be aware of. And another important consideration with respect to delegation of authority is that you should review your delegation. Best practice says review annually. So is it working well? Are there challenges? Is there more you can delegate? Do you want to take some powers back? I found this statement in an old province of BC document, and I thought it was a good one, and I thought I would share it with you. So delegation can assist the regional district board to focus on the needs of the region as a whole. This may help the board develop a stronger regional identity and an enhanced ability to deal with corporate or region-wide issues. So the intent of delegation is not to say, you know, we don't really care. Somebody else can make the decision. It's going to make our meeting shorter. That's not the intent. The intent is to say, you know, are there sort of routine activities or tasks that come before us where we're consistently making, you know, the same types of decisions, and you know, do they really need to come to us? Can those be dealt with administratively? And can we focus on the things that are have more of a regional impact or have more impact on our overall policies? So under your current bylaw, Bylaw 4267, delegation currently includes all development permits except for applications for subdivision in areas A, B, and C, and commercial, industrial, and multifamily development permits. So you do at times have development permits come before you for subdivision in other areas. And the reason for that is that there's a bit of a disconnect between your referral procedure in the current bylaw and the delegation section of the bylaw. So the referral section says that any proposed, any development permit where there's proposed subdivision of 3 or more lots is to be referred to the APC. And we have been, as staff, taking those forward to the committee for a decision. But in fact, the general manager does have the authority to make decision on those applications today. So I wanted to point that out to you. So there is a disconnect there now. The bylaw also does provide the ability to obtain security. When I talk about security, I mean like landscape security, so financial security to ensure that works or landscaping are completed in conjunction with a development permit. So typically the types of development permits that are being signed off at the staff level today include riparian areas protection regulation development permits for agricultural protection. Those are the most common. So all of the environmental development permits are dealt with at the staff level, unless of course they involve a variance, and then you'll see the variance application come before you, because of course that power can't be delegated. Under proposed bylaw 4379, all development permits and related powers would be delegated. And the rationale for that is as mentioned earlier, when a development permit meets, or when the application meets all of the applicable guidelines, the local government is obligated to issue the permit. And that is a principle that's well established in case law. And local governments have gotten into trouble in the past where they've taken you know, other information into consideration when considering development permits that's not related to the specific guidelines. So the guidelines are really important. And our harmonized OCP will have a much cleaner set of development guidelines, which should enhance the quality of development going forward. But this is a separate issue. So we have you know, quality issues that are being dealt with under the OCP and the Development Approval Information Bylaw. This is simply about processing applications. Minor and redundant covenants. So we typically have covenants that are established as a condition of a permit, which requires an applicant to do something. It might be a condition of a rezoning that requires an applicant to do something. Once that thing is completed, the covenant becomes redundant. And so that's an example of a application that you know, we're spending a bunch of time preparing a report to come before you. to essentially request that you do something that is really administrative in nature. We even have examples of covenants which say that the CVRD will be required to release the covenant once the applicant has completed the requirements. So there is really no choice in the matter. Minor liquor licenses and special events permits. So we, from time to time, get applications that come before us which require the CVRD to comment on. Certainly, a new permanent liquor license application would continue to come to the committee for discussion. And it's simply some of the smaller minor applications that could be dealt with at the staff level. Strata conversion of occupied buildings. This is an interesting one. Apparently, this power was previously delegated by the CVRD board to staff, and the power was delegated under the old Municipal Act by resolution. And so it is my understanding, I know that Mr. Tippett is on the call today and could speak to this later, but it's my understanding that there have been applications that have come forward that have been dealt with administratively based on the prior delegation of authority by the board. The proper place for that delegation to rest would be in the development procedures bylaw or in a delegation bylaw. And of course, the legislation has changed. We no longer have a municipal act. We have a local government act, and we have a strata property act. And so it would be, this is a, simply an opportunity to clean this up. Certainly the board could say, we think that we should have that. We don't want to delegate that authority. We want to retain that. And then that's a simple matter of then removing that from the bylaw. The board could, on the other hand, say we could expand the types of occupied buildings that could be approved at the administrative level, and that will just require some discussion. And then execution of approved agreements. So really, this is just to say that once the board has already made a decision to do something, to enter into an agreement, that staff wouldn't be coming back to you. I've included a summary table here, and this is just for convenience. And I realize the print is probably a bit small, but feel free to come back to this later. I did want to point out, in terms of the application assessment process, under the current bylaw, we receive an application file, we open it, and then we review it for completeness. And this creates all kinds of challenges because we often receive applications that are incomplete. But what we have is a situation where we've already opened the file. So when we talk about starting the clock on the length of time it takes to process an application, we want to start the clock when that application file is actually complete. And so we don't want to be spending a whole bunch of time working on the file if all of the material is not there. So under the proposed bylaw, we would take the fee. We would do an administrative review to make sure that the application is complete. And once that's done, then we would open the file. In some cases, we find that they've applied for the wrong thing, or they need a development permit and a variance application. So it will be a cleaner process. Referrals, as I've noted, so right now the bylaw speaks to referrals to APCs and referral to agencies. It actually, what's interesting is that it allows staff to determine what agencies should receive referrals, and this is specific to bylaw amendments. So OCP, zoning bylaw amendments, phased development agreement bylaws, land use contract amendments. So staff determine which agencies should be referred the application, they send it off. APCs are referred bylaw amendments. They're also referred development permits for commercial, industrial, multifamily development. And as I noted, 3 or more subdivision applications, so 3 or more lots. So development permits for subdivision of 3 or more lots. So under the proposed bylaw, that referral procedure would be pulled out. But what I'm suggesting is that you need to have a complementary policy which establishes your process for referrals. And the nice thing about having the referrals dealt with in policy is that it provides you flexibility. So if you want to refer a development variance permit, for instance, you could do that, you know, under the policy. If you decide you've got a very simple bylaw amendment, you could decide you don't want to refer it. So it would be a sort of more flexible way to approach how you deal with referrals. Delegation, I did talk about, and then public hearing, the current bylaw talks about public hearings, and really it's just reiterating what's in the Local Government Act. So that doesn't need to be restated in the bylaw. Again, there can be some policy around how public hearings occur. So moving on to issues and opportunities, and I included a picture of an elephant because it's the, I'm sorry, it's the elephant in the Zoom. And I thought he was cute. Okay, so referrals. So why send referrals? So you should be considering referrals because you either want to gather more information or there's a legislative reason for doing a referral. So there are cases when we're required to send referrals. So for instance, official community plan amendments have to be sent to the Agricultural Land Commission, to the school districts. And they also have to be, you also need to consider whether or not to consult with First Nations. So that's specifically embedded in the official, or sorry, in the Local Government Act. Typically the process, as I noted before, is that staff will determine who to send referrals to. And then when we bring a report forward to you, you make a motion to accept those referrals. So that's not, it's not wrong, but you may want to consider having a more sort of conscious discussion about referrals when you're dealing with OCP amendments. And so we can have a sort of a process discussion about, you know, should you see the application before it's referred out versus what we're doing today. And then who should receive the referrals? Excuse me. So advisory planning commissions, community parks advisory commissions. Thinking about parkland, requirement for parkland dedication, for instance. If you were to read the Local Government Act, it would say that a decision around parkland dedication should actually be referred to an advisory planning commission. But the norm at the CVRD is that those questions are sent to the Community Parks Advisory Commission. Sometimes we get direction to refer to two different commissions. So to refer to an advisory planning commission and a community parks advisory commission. So what happens when you refer an application or request for some information or decision to both and you know the referral response is different? How do you deal with that? And then what about other agencies? So again, the current procedures bylaw deals with APCs. What about the province of BC or the Agricultural Land Commission or Island Health or the school districts? And what about all your local First Nations? You know, how do they factor into your public consultation process? They're not dealt with in the procedures bylaw. So could we deal with consultation and engagement through a policy? And when should referrals be sent? As I said before, are there cases when it isn't necessary to send a referral? Or are there, you know, seemingly minor applications that really should be referred? And then public participation. So the Local Government Act for various types of applications will set out requirements for public notice, requirements for notices to be published in the newspaper. The CVRD does distribute notices by hand to owners and occupants of adjacent properties. And I think there was a reference earlier to the 60-meter radius. That is something that we are reviewing. It's a little more complicated than you would think, because a 60-meter radius might be appropriate in an urban setting. It probably isn't appropriate in a rural setting. So it really will vary from community to community what that notice radius should be. You could consider increasing it. 60 meters is certainly a very, very low radius for notification, and we might want to consider in expanding that. Keep in mind that when you do expand, if you do expand the notification radius, it'll take a little bit more time for staff to do the notification, and it'll be a little bit more costly as well. And the other issue of the public hearing. So the public hearing is the public hearing, and it's really not the time for a question answer session about an application. And unfortunately, what happens from time to time is people come to public hearing knowing very little about the application that's being discussed, and want to ask questions and want to get answers. But it's not possible. This should be considered the very latest, stage in the public consultation process. So is there an opportunity to have a community information meeting in advance of certain types of public hearings? So can we start to distinguish between a bylaw amendment that's minor versus a bylaw amendment that's major, and incorporating some more consultation into those major amendment applications? And then, of course, think about how people get information. So they're going to the CBRD website. They might be looking for information on social media, on Facebook. They might have gotten a copy of the APC's referral package. They might be then, sending you emails. They might be sending staff emails. They might be coming to public input period or coming to the board as a delegation. So think about all of these things in the context of your different application processes and what makes sense. So I've included here, and I'm getting very close to the end. Thank you to everyone for being patient. This was presented to the APCs when we did orientation, just as an example of a process for a development permit. So let's say this is a development permit for, excuse me, for a new commercial building. Typically, we'd have a pre-application meeting. Applicant submits the application. We do a review, refer to the APC. The APC makes a decision, provides a recommendation to the EASC. EASC will recommend to the board, refer back to staff or deny, and the board will make a decision. The permit is issued. Sorry, I'm getting a little bit dry here. Okay. And then on the bylaw amendment, similarly, pre-application meeting, we get an application, planner reviews the file, referral to APC and agencies. We go to the Electoral Area Services Committee, wherein then the committee then will either recommend to the board to proceed with bylaws and a hearing, refer back to staff, refuse. And then we really move into the statutory process. What's interesting about this, and this actually came up yesterday, I think it was Director Kuhn that said, it's not typical for us to refer bylaws to APCs. And I was thinking to myself, well, it's not typical for the CBRD to refer its bylaws to APCs. There are other local governments that approach referrals differently. And rather than referring very early in the process, they'll wait until the committee or the committee of the whole has had an initial look at the application, and then they'll decide whether or not to refer to an APC, or they'll let the process go a little further, and they may suggest to staff to bring back draft bylaws, and once they've had a look at them, then they may decide whether or not they want to refer those bylaws to an advisory planning commission. So there's different ways of approaching how you deal with referrals and bylaws. So that's about it. I included a cartoon, and I won't leave that up too long.
Too funny. Thank you, Ms. Cheryl. I've had a request for a 10-minute break after your presentation. So I think it's probably a good time now before questions. So we will come back at 2:45.
Madam Chair, that's 25 minutes.
Oh,
2:35.
35, sorry. Yes, thank you.
Excuse me, Madam Chair, we are live.
Thank you very much and welcome back, everyone. And thank you very much for that presentation, Ms. Cheryl. Hope you had a chance to get some water. You went through that very fast and we appreciate the comic relief. Very, very much appreciated. Thank you. And I will move now to questions, and I have a bit of a speakers list so far. I have Director Wilson, Acton, and Salmon. Go ahead, Director Wilson.
Thank you very much, Madam Chair, and thanks, Anne. That was really a good presentation, and you showed one of my favourite cartoon characters at the end there. Anyway, that's good. I've got a couple of questions, and one of the things are I fully agree. You know. That there are changes that need to be made to the old model because it no longer works as it should do because of the volume of work that you've got and the different things that you're dealing with. And one of the questions is initially you've said that there are times when you will have to bring it to the Area Planning Commission. But would there be any involvement with the area director in question initially, or would you have to wait until that comes to the area planning commissions?
Could you just hold on that answer, please, because we've lost a director. I'd like him to be able to, hopefully he's able to hear. Director Martman has disappeared from my screen. I don't want him to miss out in anything, so I'm not sure what's happened.
Oh, there he is. He's back again.
Okay, go ahead. Go ahead, Ms. Cheryl. Sorry.
Thank you through you, Madam Chair. So the Local Government Act does provide for either an electoral area director or the board to make a referral to an advisory planning commission. So certainly through a review of your referrals policies, we could look at integrating a step in the process where it's check in with the electoral area director to say, would it make sense to refer this application to an APC?
Yeah, that would
certainly
be great.
There is an opportunity to do that. And I wanted to say that I know that you're copied when an application file is opened, and in the past there wasn't a lot of information in those in that correspondence. And I believe that now our staff are making a more of an effort to let you know what the application is for, so you have more of a heads up, and so hopefully that will help as well.
That's great. And follow up, please, Madam Chair.
Go ahead, please.
Thank you. And one of the other things is that I heard you say was the delegation of authority, and that's something which the points that you brought up there with it should be beneficial. Of course, it should. And by the way, your pronunciation of the Latin is very good. And one of the things that you said that certain powers cannot be delegated. For instance, you can't bring it to the board once the delegation is given to you. But I think the main thing that I picked up on this is what happens, you delegate to, for instance, yourself. What would happen if you or anybody as the delegated person leaves the organization or is not available to make that decision? What would the delegate have an alternate delegate, or what happens in that situation?
Go ahead.
Thank you, Madam Chair. So So the bylaw does provide for, I believe it's in the definition of the delegate or the general manager could be the person acting in the position of the general manager in the absence of the general manager. So
Okay.
there is always a person who would be available to act in the capacity of a delegate. And certainly, you know, if your delegate were to leave the organization, you would probably want to review your delegation provisions to say, you know, should they be changed, expanded? Should they be pulled back until you have confidence that, you know, you are delegating to the right person?
Yeah. Okay. Thank you very much.
I'm still concerned about Director Martman. Is he able to hear us? Because, I mean, being a new director, there's a lot of learning here, so I'm worried. Can't hear you. You're on mute.
Madam Chair, there was a little yellow triangle indicating that he was having network connection issues. I don't see that there now.
Okay. So I'm hoping he's able to participate. That's what I'm concerned about. So how he'd be able to hold up his hand might be a participant. He could do that remotely too, or speak up. Okay, go ahead, Director Acton.
Thank you, Madam Chair. I have lots of questions, but I'll just do a couple at this time. I guess just for perspective, how many development permits do we issue in a year, and how many come to the board?
So that's a great question. I would have to go back to development services to get the stats for you. It may be in the order of 4 dozen.
Well, I think it's important because if it's something that needs to be changed so that we can streamline it, well, then how big of a you know, how much of our time is actually spent on this?
Absolutely. I think it's actually a great, I'm sorry, it's actually a great question. You know, as we go forward with implementation of a land management system, we're going to have the opportunity to prepare reports. And one of those reports will be, you know, a report on development permits. So by type, you know, was it a decision by the board or by a delegate, and you know, what was the outcome? And we would have some good stats for you. But I could bring that information back to the board. But you know, in terms of maybe an annual review of delegation provisions, it might be good practice to have an annual report on the decisions that have been made by the delegate, right? So you have that information, and then that informs your decision-making process.
Thank you.
Okay. Follow up, Director Acton, go ahead.
Yeah, so I have some concerns about giving up some of this authority in certain instances. And this board actually, at the beginning of our term, gave up, this isn't the first time that changes to our development procedures bylaw have come forward. And we gave up a lot of our power and delegate and authority then. And I think we didn't quite understand because it was early on in the term. And I think before we make any decisions of doing any of this, we should also be talking with our lawyer and have kind of like a workshop we did yesterday, because it was really sobering to have that workshop with him and have this kind of fresh perspective of the strength of the regional district and some things we didn't hear before. And so I think that would be really prudent on our part. I guess one of my questions, that was more of a comment, but I shared a picture with everyone today, and that property that was in the riparian area. So they did get a permit for stairs because that triggers a development permit. So, but in my mind, I would think that development in a riparian area is a variance, or I think we gave up that delegation early on in our term, and something like that's so important to the community, almost like every variance or development permit that's in a riparian area around Shawnigan Lake or Cowichan Lake should come to the board. And so is that not, where's the How did that happen, Ms. Cheryl?
So I'm going to make a guess about the situation that you were referring to. I have been looking at a situation involving the construction of stairs that was done without a permit. What happens when somebody constructs something within a riparian area and they haven't gotten a permit, and we undertake bylaw enforcement, we require them to get we require them to get a QEP involved, right, and to provide us with an assessment, and we may require them to remove the stairs if for instance, it's not consistent with the official community plan or the development guidelines. We might require the removal. Removal requires a development permit. It's kind of a funny thing, but we deal with those situations when we deal with them in accordance with the guidelines that are in place.
I guess just this is where the lawyer comes in, because the lawyer had mentioned there's certain bylaws that we could use to protect riparian areas. And in this case, the person actually got a development permit, but continued to remove all the vegetation. And still, my understanding is there wasn't much that we could do because there was a development permit issued, and now their construction had begun. But I think that's just an example that we need to be really careful about delegating some of our authority over.
Ms. Cheryl?
So I think that it goes to the substance of the bylaws. So there are some challenges with respect to enforcement of development permits. So because they're not regulations, we don't ticket for them. So when we undertake enforcement with respect to development permit violations, we're going to court. But there are other options with respect to riparian area protection. So you can certainly look at amending your zoning bylaws to increase your setbacks. You can establish landscaping and screening provisions, regulations within your zoning bylaws. And those are things that we can ticket for, and we can ticket for on a daily basis. So that's the substance of the bylaw. And that's kind of what I was getting at during my presentation, is that you've got a process for reviewing applications, and then you've got the substance of the bylaws themselves. And we've got to deal with the substance of the bylaws that are before us today, not what we want them to be or what they ought to be. We use the framework that we have in place today.
Thank you. I turn to Director Salmon, then Director Kuhn. Any other hands? And Director Morrison and Smith.
Yeah, thank
Director
you. Thank
Salmon.
you. Thank you, Ms. Cheryl. Very interesting. I wrote down 5 or 6 questions, but I'll just ask a couple. One, that slide you had of our overall goals here, and three things. It's interesting, the one that said consultation with the public. Who are our client? I just wanted to confirm that, because often in practice it seems like our client is the applicant. That's who we're helping through the process. So is that beyond just the theory? Does that affect our work?
So through you, Madam Chair, the what I was getting at there was that planning services are paid for by our taxpayers, right? By our electoral area taxpayers. So they're as a group, they're the clients of the service. Certainly applicants are clients as well. They're also taxpayers. But when I talk about the people that benefit from the service, they're the taxpayers, right? And so whether or not you're an applicant, that development may impact you, right? So we want to ensure that we are expanding our ability to communicate with people better, that they have clear information, that they're getting the right information, that they're not getting, incorrect information through social media, and that, the best decisions are made on the right information.
Yeah, great. I think that's very important to remember who pays for it all. Follow up, Madam Chair.
Go ahead.
So other questions. So this old bugbear of track record of permit applicants. When you're speaking about that, I was wondering, so when we do up the guidelines for a permit bylaw, would it be permissible, for example, to say the board may consider the compliance record of the applicant? And you're shaking your head. So
That looks like a
No.
no to me.
No,
case
and
law or
you
in
know,
the act?
thank you, Madam Chair. So this was a sort of a question I think that came up at one of the Advisory Planning Commission orientation sessions, right? And what I said to the APC members was, you have to evaluate the application on its own merits. You can't evaluate the application on the applicant's merits or past past wrongs. You evaluate the application that's before you, and you look at it from land use perspective, and you don't take other information into consideration. We know that, you know, it is possible to do that if you had different powers, for instance, business licensing, but that's not what the regional district has right now.
And is that based on
Follow up,
case
Director
law?
Salmon?
Sorry, yes. Case law, or is that somewhere in the act?
I won't, I mean, I'm not a lawyer, but that is best practice.
That's quite interesting. Sorry, just a comment, because it does seem, if it's non-compliant specifically to do with the very case you're considering, it's not like it's an irrelevant non-compliance from a past thing. It's a directly
Right.
relevant.
So if there's a, if I may, if there's a non-compliance issue occurring on that, you know, same property, for instance, then we can deal with that through bylaw enforcement, right? That's the way that we deal with that. But you have to look at, you know, an application, like I said, for something else on its own merits. Of course, you know, when you have a zoning bylaw amendment in front of you or a development variance permit application in front of you, it's not like a development permit, right? So development permit, applicant meets the guidelines, we're obligated to issue the permit. If we have, if you have a variance that you're discussing, there may be reasons why you don't want to accept the variance. I mean, I wouldn't take the applicant's performance in when considering, but there are other factors you can consider. You know, impact of the variance or impact on the proposed amendment on the broader community. That's where your discretion. That's how your discretion can come into play.
Thank you.
Okay, thank you. I'd just like to let the committee know that Director Martman is with us by telephone, but also to let him know if he'd like to speak up at any time, but he is listening. So I just wanted to make sure that everyone knew that. And Director Kuhn, go ahead, please.
Yes, I'd like to get back to the delegation of powers. What I'm interested in, the powers you're going to have are basically positive powers, aren't they? Like, you don't really have the power to decline, or do you? Because what I'm interested in is, if a decision of yours is just a routine thing, which is always usually a positive thing, right? Yes, okay, you're fine, you go along or whatever. The moment you decline, that's a whole different story. So what I'm interested in, let's say, could you answer that question first? The majority of your decisions are positive, right?
I would say, from my experience, the majority of my decisions have been positive. However, I have refused development permits. One example was a development permit for freestanding signs in conjunction with a business. Clearly did not comply with the development guidelines. And if, like I said, the application didn't comply with guidelines, my professional obligation to the CBRD is to deny the permit. Now, what happens when a permit is denied by a delegate is that the applicant does have the ability to appeal to the board, and the board could make a different decision.
That's what I was interested in. Yes. Okay.
Yeah.
I just wanted, because yes, in the majority of these cases, you have the final say, and it's usually a positive say. But if there's a dispute, it can come back to the board. And so, yeah, okay, that answers my question. Thank you.
Right, we turn now
Yeah.
to Director Morrison. Oh, Director Kuhn, you have a follow-up?
No, Anne has another comment.
Oh,
I
okay,
actually
sorry.
have
Yeah.
a follow-up.
Yeah.
I wanted to say that you know, the other option, there's approve, deny, and then there's approve subject to conditions. And I have also issued development permits subject to conditions, like registration of a restrictive covenant to protect wetlands or streams. So that's an example as well.
So I could have one more comment. So to round it up from my thinking is really the vast majority of the decisions you would be making would be decisions that are routine, that the board would basically pretty well always say, yeah, okay, in favor. I mean, I've seen it done in the past. I mean, that's and your aim is to take that away from the board so that you can do it, because it's kind of an additional burden to the board that isn't necessary. And I agree with that. Thank you very much.
Turn now to Director Morrison.
Thank you, Madam Chair. I want to go back to the areas around some of the information you brought to us around the public involvement, referral to APCs and the likes. And I think there's a couple of us around the table that might have served in parks commissions and APCs before. And so maybe a revision, it's time for a revision because of how different things are. But I just want to go back on one of your slides. You had public involvement and you had referral to APCs. Now, when I first started serving on APCs, they just literally corrected the circumstances where we were having applicants showing up with lawyers and opponents showing up with lawyers to APC meetings, and if it was almost like if they got the approval of the APC, then it was a done deal, and a lot more effort was put in that. So I just want to go back to the fact that we're ultimately the people that raise and lower our hands. We're the decision makers tasked with coming into our meeting with an open mind. So a couple of things. We get the notification when an application is made. And on the rare occasion with maybe an important application, we may participate in a pre-application meeting with staff and the applicant. But beyond that, I've always been instructed that it's best practice that from that point on, the director not have any engagement in it, because we're ultimately the we're ultimately the decision makers in committee and at the board. But the other thing I wanted to explore, and this is about best practices and fairness to all parties involved, is the idea of when an application becomes public. Now, I always thought that the application became public when it was published on an agenda and presented at the committee table. And that's when everybody had the crack at it to review and read the information and the professional advice brought to the committee through the report. But we're now starting to see referrals made out to advisory planning commissions being distributed to members of the public, and I don't know that we're providing a fair process when the applicant isn't able to be present when there's deliberations going on in the community, which that was the whole idea behind an advisory planning commission meeting, is the applicant has the opportunity to present and discuss and debate and answer questions for the advisory planning commission. So when do you view an application to become a public document? Because I'd like to get that clear in my mind, because I might start going to the advisory planning commission meetings if that's the recommended practice. I don't think it is, but could you give me some of your thoughts on that?
So through the chair, the Advisory Planning Commission and the Community Parks Advisory Planning Commissions are bodies of the board. When they meet, they're meeting in public, so in a public meeting. So when an application or when an agenda is published for the APC or the Community Parks Advisory Commissions, and there's referrals attached to that, that information becomes public. So once the APC or the Community Parks Advisory Commission agendas are published, the information is public, in the public realm.
Follow up, Director
So-
Morrison?
So just a quick follow-up. So given that that's the point at which it becomes public, when you just did the orientation with the advisory planning commissions and the like, was it made clear that the best practice and the is that the consideration of that matter is only to be considered at that meeting with the applicant present, should the applicant be able to attend and has had the invitation? Is that not the procedure that we're supposed to follow?
Through you, Madam Chair. So the point of having an appointed commission to make comments on the application is that those individuals are intended to bring the community context or the community lens to the review of an application. They're not intended to be a shadow council. They're not, another elected body that makes a decision. They're a referral body, and they shouldn't be, taking an application and shopping it around within the community to gather comments. They're being asked to provide their own opinions, and then to provide a referral response to the board based on their opinions. Because if it's the other way, then what's the point of having the commission, right? Then just have a community meeting.
Thank you. I see I still have Director Smith and then Director Acton. Go ahead, Director Smith.
Thank you. From the chair to Ms. Cheryl, when I was watching the slideshow, there was 2 items that could not be delegated, and one was a development variance permit, and what was the other one, please?
A bylaw amendment?
Oh, a bylaw amendment. And I was just wondering about rezoning. Is it something that cannot be delegated, or does it remain?
That's correct, because rezoning is a zoning bylaw amendment.
It's a bylaw amendment, yeah. Okay. And one of the other things is when people read the bylaws, there's an intent of the bylaw, possibly, and I may read the bylaw, and for me, the intent is different than how somebody else reads the bylaw. Is that a bit of an issue for delegating to one person to only have their interpretation of the intent?
So through you, Madam Chair, I think what you're referring to is the interpretation of development guidelines. Is that correct? And the discretion that would be exercised based on interpretation of development guidelines. Regulations should be really clear. The height is X, the setback is Y. Those things are very clear, right? Development permit guidelines are their guidelines. They're not written right like regulations, so there may be an element of discretion that needs to be exercised in their interpretation, but it should be pretty clear. And certainly with the new or updated development guidelines that should be coming forward in the harmonized OCP, they've undergone a fairly rigorous review by legal counsel to ensure that they're pretty crystal clear in terms of how they should be interpreted. The courts would say, reading a zoning bylaw, they don't really care, what the intent behind a regulation was. They read it as they will read each word and take the regulation literally.
Follow up, Director Smith, go ahead, please.
Thank you for that clarification. As we're moving into our modernization and our development permit areas, I am glad to hear that we are making sure that those areas are definitely very clear, because I know in reading some of the other ones that are current are definitely lacking, and then it depends on how somebody interprets the intent of that wording. So I'm looking forward to, I'd love to see those development permits approved tomorrow, because I think we're all needing them as soon as possible. Anyhow, that's my comment for the moment. Thank you.
I have Director Acton and then Director Morrison and then Director Nicholson. Director Acton, go ahead, please.
Thank you, Madam Chair. I guess, so my question is, can you please explain the rationale behind suggesting the OCP amendments be delegated to the signing manager or to the development manager? It's not?
No.
Okay, so I wrote it. So there's no OCP amendments going to be on the list of, okay.
No.
So so that would be the same as a variance or a bylaw amendment, of course. And okay, and no community plan.
No, that all needs to come to the board.
That's always
That's
to the board.
very high level policy stuff that really needs, that's not appropriate.
But you said bylaw amendments and variances would come to the board.
That's correct.
And OCP amendments.
Yes. Yeah. So when I talk about bylaw amendments, so an official community plan, it's adopted by bylaw. So it's called an OCP bylaw. So we have the OCP bylaw, we have the zoning bylaw, we might have a land use contract bylaw, a phase development agreement bylaw. So anything involving a bylaw amendment needs to go to the board.
And in the report, it did mention phase development agreements, but those would go to the board then?
Absolutely, yeah. A phase develop, we've probably dealt with, I think, Mike would be able to answer this probably better than me, but maybe 1 or 2 phase development agreements in the CVRD. And there's a fairly rigorous process that will go into those types of agreements. Yeah, Director Yanni Dinarno is very, very familiar with the phase development agreement.
Okay, I have Director Acton, you're finished? Okay, I have Director Morrison, Nicholson, Salmon, and Martman. Director Morrison, go ahead, please.
Thank you, Madam Chair, through to Ms. Cheryl, and sort of shifting gears a little bit here. So my electoral area is one of few in our region. I think Area H might be another one that is got very few in the way of development permit areas, and it's folks kind of like it that way. But some areas have a lot. And one of the things that's been noticed by my APC and community members, and this is just not my area, is the length of time it takes for applications to make their way through the process. So, you know, I get that efficiency and everything is part of the target here, but staff have informed me that my APC has sent a recommendation through that will appear in our next EASC meeting, requesting that application recommended timelines be developed for development permits, OCP amendments, rezonings, and we don't have those. And partly the reason why they're asking for it, we just dealt with a single lot subdivision in the Poldy area that was 4.5 years in the queue. Now, obviously, it wasn't a complete application when it came in, and there were a whole bunch of reasons and different staff members that held the file. They're not laying the blame solely at the feet of the staff. The applicant realized that he had a role in that as well. But can't we develop targets that will give some reasonable expectation for applicants and our customers, the public, to be able to expect that if you come in with a fairly simple development permit for subdivision where there's not a lot of invasive plants involved, that you could expect that to make its way through the system in 3 to 6 months? There's my question.
Go ahead, Ms. Cheryl.
Through you, Madam Chair. So yes, absolutely. I think in an application or development application processing policy, you could certainly establish some time limit or processing targets. And I've actually started to do that. It is somewhat dependent on what you decide to do in terms of delegation. So where we get development permits that have been delegated to the general manager, where those applications are very straightforward. And I'm thinking about, there are a number actually in agricultural protection development permit areas where the request is simply to construct a single family home, for instance, or an accessory, some sort of an accessory building that's otherwise compliant with zoning. We can, if they are obviously complying with the development guidelines, turn those applications around very, very, very quickly. It could be, a less than 30 days. When we have to, and I'm not saying that this is a terrible thing, but when we bring applications, to the Electoral Area Services Committee, staff are preparing, they're preparing a staff report. They're preparing, they might be preparing a short presentation for you. So there's extra time that goes into processing those applications. Similarly with advisory planning commissions, when we're referring to advisory planning commissions, there is extra time that goes into that process. Sometimes we can't, under the current framework, we have very little control over when we might get a referral response in some cases. So it would be nice to kind of have some clear timelines and targets for different types of applications. I've thought about, is there a framework we could create for determining the difference between a major and a minor application, and what would that look like? And it would be nice to have that conversation with your advisory planning commissions to say, what are the applications that you've considered that really you looked at and went, why is this even coming to us? Or what are the applications that came before you where you said, holy cow, this is a huge development. I'm glad that we have the opportunity to have, some input into it.
Follow up, Director Morrison, go ahead.
Yeah, I'll be brief, and I'm glad that you ended with that example because I was severely chastised by my APC once for referring a development permit to them where they said, this is crazy, this should go straight through and the GM should sign off on it. So there is merit for that. I would just say that there's this area that doesn't have a lot of those burdensome requirements. We'd like to see the timeline speed up, and I will be asking at each meeting, so you might as well tell Mr. Limshu in advance that he better look up the original date of application and all the things that he's going to be presenting, because I'm going to be asking the date that we've first officially called them a complete application. Thank you.
I go turn now to Director Nicholson. Go ahead, please.
Thank you. What I find helpful is looking at the tables that are on our website of the applications and their progress, where they're at. You can check by area what's going on, which is really useful. We didn't used to have that. I have two quick questions. I am very unfamiliar with this term phase development agreement or area or whatever. It's new to me. And I'm wondering if we have set timeframes for those kind of things or how that works. And I have another question, which is when you did your presentation and you had, or Ms. Cheryl, you had in areas, I think it was AB
C and D, maybe the development permits for subdivision did go to EASC or to APCs or something, and I wasn't clear why that was in that particular area. So those two questions, thanks.
So through you, Madam Chair, on the first question on phase development agreement. So what a phase development agreement is an agreement between local government and an applicant or a developer to provide the developer with certainty over what they're going to be able to build over a period of time. And it might be 5 years, it might be 10 years, it might be 20, 25 years. And it's kind of interesting. There's that principle where you as a board can't fetter the discretion of a future board. And that's not really 100% true, because if you entered into a phase development agreement with someone, you're actually in effect sort of fettering the discretion of a future board, because once that agreement is signed, that developer does have the ability to move forward with the development that they were promised at the time the agreement was signed. So an example is the Cowichan Bay Estates. That's correct. Chair Yoni DiNardo, yes. So Cowichan Bay Estates was a phased development agreement, and I believe the permission was granted to build, a certain number of units over a period of time in exchange for certain amenities or parks being provided. That's generally what happens with those types of agreements. But generally, they also involve rezoning or an OCP amendment. I mean, they're very complicated processes that involve multiple steps and will involve, similar to an OCP amendment, there'll be a public hearing. They're not sort of things that can be done very quickly. And so I wouldn't worry too much about not knowing much about those right now. If we bring you a phased development agreement application, we will take the time to very carefully explain what it is and the process that you would go through to deal with it. And the other question was around subdivision. So the current development procedures bylaw says that staff will refer applications for subdivision of, I believe it's 3 lots or more, but it delegates authority to the general manager to approve development permits for subdivision, except for in areas A, B, and C. So that's the disconnect. It's a bit odd, and in reality, it's just odd because you set your commissions up for the expectation that they'll be able to provide meaningful input to those applications. And that may be possible if there's a question around, for instance, parkland dedication, where that should be located. But other than that, there's very little ability to sort of, influence the outcome of the development permit when, they may otherwise be complying with the guidelines.
Thank you. We move on to Director Salmon. Go ahead, please.
Yeah, thank you. So yeah, I have a couple of areas that I've got concerns about with increasing the delegation powers. One of them, Director Wilson asked about this a little while ago, but just to be clear, so that the Latin one, that means no subdelegation. So is that in effect limiting flexibility? Does that mean that once we have this bylaw in place that delegates, even if there's a very significant, say, development permit, it could not come to the board?
So through the chair, so yeah, so no sub-delegation. So, if I was a delegate, then I wouldn't be able to just to say, to, the manager of development services, you go ahead, you can review that application and make a decision on it. So I have that authority that's been entrusted to me, and I need to make the decision. So part of the uh-oh.
That's good. You're all right.
Okay, I can't see you, so I don't know what's going on. As long as you can see me. Okay.
We can see you and we can hear you, so I don't know.
Okay, that's extremely odd. Okay.
Okay.
I think I've lost my train of thought. So yeah, so I guess there's the question is, when you're considering delegation of authority, if there is an element of if there's a significant element of discretion, then you may not want to delegate that authority. And so, you know, I question, for instance, the previously occupied residential buildings. You know, that's in the draft bylaw because that was previously delegated to staff. You can decide whether or not you believe that that power should be delegated. I mean, the Act specifies the things that need to be considered when those types of applications come forward. But you may or may not want to delegate that authority, right? And the same applies to, you know, if it's a complex development application, so multiple development permit areas, it gets broken down, and you know, the applicant has to comply with all of the applicable guidelines. So they can be treated like almost like individual applications. And it may be a major, you know, development. And often what happens with complicated applications is that there are also other approvals that are needed, either rezoning or they might need variances. And those need to come before the board before any decision is made on a development permit.
Follow up.
Go ahead.
Okay, I'm just not totally clear. So it does seem though, once it's in the bylaw, it cannot be redelegated case by case. Like it can't be sent back to the board. If we've said the development permit goes to the general manager, that's it.
I think that I understand. So what you're talking about refers to sort of opt-in, what I call opt-in provisions. You know, if an application came to me, for example, and I said, oh gosh, this is, you know, an application for a liquefied natural gas plant. But it's a development permit, it complies with the zoning, they meet all the guidelines, now I have to issue the permit. Well, great, I get to be the one that wears that, right? Could I then say, no, I'm not going to make a decision on it and bring it to the board? I think that's what you're asking. And we need to ask for legal advice on whether there's an ability to have an opt-in provision for certain types of applications. It might be possible to do that. And it might be that there are certain types of applications that you wouldn't want to delegate. And that might be like, you know, a development permit for industrial form and character, let's say.
Okay. Follow up. One more.
Go ahead.
It's another example, I think, in the case of covenants, say. I mean, we had a case here in Area A where covenant was along the protecting vegetation along the scenic part of the Malhat Drive, and it was going to be removed in the case. It had been there for years. It was going to be removed in for the process of a subdivision, but I only really found out about it by accident, and the community was quite supportive of keeping it, so we kept it. But in the case of I think it normally would have just, in the normal case of business, disappeared. So I'm concerned about that kind of scenario as well.
Yeah, so through the chair, that I think that's one that would still come before the board. It was that isn't, I wouldn't suggest that would be the type of covenant that would be, could or should be dealt with at the staff level, because it involves exercising discretion as to the value of that covenant. And perhaps some more clarity is needed around the types of covenants that could be dealt with at the staff level. And in my view, those would be things like, you know, a covenant where, you know, the applicant is required to complete construction of a pedestrian pathway in conjunction with their development. It was condition of their rezoning, and the covenant requires them to complete the trail and to a certain standard and to have it inspected. And then once it's done, right? And then, so what happens is when land is subdivided, if there's a covenant on the parent parcel, that covenant is transferred automatically to every new parcel that is created by subdivision. And so there are times when, you know, things happen and we need to have those things removed because they really don't make sense, and then they create a burden on a future landowner. So those are the types of things that staff had contemplated could be dealt with at the staff level versus a covenant that says that's restricting a particular type of use, for instance. So let's say a covenant that says no home occupation for automotive use. An applicant comes before us and says, well, I'm trying to sell my property. I've got this covenant the CBRD wanted, and it's creating a problem. I think it's devaluing my property. I can't sell my property because I've got this covenant. So we're going to come to the board and say, is it important that that covenant remain on title, or would you be open to removing it? And that's something that I believe that's, it's a question about a use that you've restricted. And if the zoning isn't otherwise restricting that use, then maybe you should keep it on. And so that's a question for you. That's not something that I believe that staff should deal with.
Thank you.
Thank you. I just reading the section in the draft bylaw on covenants, and I think I'd be more comfortable if that just was not delegated altogether. You don't need to respond to that. I'm just commenting.
Thanks for the comment.
Okay, we go to Director Martman, then Director Nicholson. Go ahead, Director Martman.
Thank you. I have two questions. The first one is, I understand the concept of the efficiency and effectiveness and trying to find a balance in terms of what will come to the board and what stays sort of within staff. What I'm not clear on, and perhaps this is my newness to this, is this a workload shift? And if there is, can you explain a little bit about what that looks like, both for staff and for the board?
So thank you. So that's a good question. Yeah, I mean, certainly part of it would be workload shift. So focusing the work on, on policy, on, questions about variances and, rezoning applications versus development permits, which really should be treated akin to building permits, right? And those other sort of minor requests. So certainly, when staff, like I've said before, go through the process, there is additional workload that goes into preparing reports for committee. And we're happy to do that if you want us to do that, but then recognize that it is, again, slowing the process down, right? So it's like, where do you want to focus your energy? And if you like, and you're, not unhappy about having longer meetings, then we can do that. We can bring everything forward. But yeah, there is a trade-off, right? And of course, it takes longer for an applicant in some cases as well. But it shouldn't be there shouldn't be a sacrifice in or perception that there would be a sacrifice in quality as an outcome. I mean, you have to have faith that that process is going to work. Does that answer your question?
I think so. And I just didn't get the idea of the magnitude that was involved here with the shifts that you're proposing. Is this incremental shift, or is it quite a huge shift in terms of the workload that is saved by doing this by the CBRD staff? I'm not looking at so much at the board.
Right.
Well, I'll take whatever comes in front of me. But I am looking at the staff of your department and just how much, can you give an estimate of what this looks like?
So in terms of expanded delegation, I think where you would see a difference in workload would be around again, I've mentioned those minor covenant applications that are coming before you. In some cases, they have covenants that say that you don't really have any other choice but to release them, and the expanded powers around development permits related to commercial and industrial and multifamily uses. And so, I'll give you an example. We had a development permit application for an addition to a commercial building to construct a washroom. And that application took, I believe it was close to a year. to process. And, you know, we could have done that. We could have dealt with that quickly, much more quickly at a staff level. And there were a number of reasons why it took that long to process. But you know that's just an example. It's something that, you know, and it's also an impediment to a business, right, in terms of their ability to kind of stay afloat and meet you know, health guidelines and so forth. So you know, I think that you might not see a huge shift in volume, but it really depends on I think what you decide to do in terms of your referrals process when it comes to your advisory planning commissions, specifically in regards to development permits. My understanding, and I get it, I think that, you know, it's kind of fun to see applications come before you for, you know, new commercial building or new multifamily building. But at the end of the day, is that that commission going to be able to provide input that we can factor into processing the application, or was it just a, you know, a token sort of step in the process to like a tick box exercise in terms of, yes, we consulted with the APC, but, you know, it didn't really make a difference. It's not really fair to anyone.
And just a follow up, if I can.
Go ahead.
And the other question I had is very much a high level question, and it's around trying to process. I get an idea of the draft bylaw process and the modernization process, and they seem to be going parallel. At what point do they dovetail, or are they dovetailing now? Like, I just trying to get an idea how this all unfolds.
So with regards to the harmonized OCP process and then the development procedures bylaw update, they are sort of going in parallel, I guess you could say. They don't need to. I would suggest that you can kind of treat them separately if you can compartmentalize your policy and your regulations and the quality of development, et cetera. That's kind of one piece. The other piece is just how you deal with applications, right? And so I don't think you need to connect them. It might be that they kind of magically move along at the same pace, but they don't need to be connected.
Okay, thank you.
I have Director Nicholson and then Director Salmon. Go ahead, please.
Thank you. So I really appreciate this conversation, and I really appreciate that we're trying to actually, since I started 6 years ago, we've undergone a significant shift in how we do business. And this is part of this whole modernization process, which we're still in the middle of it, or the beginning of it, really. But there has been quite a bit of change. So, and I understand completely where we're going with this. And I think I agree with you, but I think it's a case of timing and providing us, or providing me, I'll speak for myself, with the comfort that we've addressed the frailties in the current system. So right now, the applications that I see and the APC sees allows us to understand what's going on in our community. I don't have any information. I now have those nice little tables that you put up on the website. I didn't have those up until recently. And, you know, the only time I knew what was going on was when we got an application. So that's a problem. And a lot of I think these problems are largely about communication processes. So it's about hearing what's happening. It also provides, when the Electoral Area Services Committee meets, the public has an opportunity to understand what we're looking at. Unfortunately, I think we could do a lot better job at being more proactive and letting the community know that they should be interested in some of the things that are going on in their community that they miss. And I think that's our job, but we don't do a good job of that. So it provides us with an opportunity to know what's going on in an area, the community to know what's going on. It also, because you have to go through a process of writing a report and being very writing a good report, then we're all assured of due diligence, right? That the application's being really thought about. And I think that even though if it was delegated to you, you would still expect your staff to provide you with a report, right? So it's not that much of a time savings. It's really a time savings on our part and the amount of time it takes to go down the committee pathway. And then the other thing that I think is really, it's been actually probably the most important thing to me has been, and given that we're in a process of change, is understanding the fundamental issues and problems with our existing bylaws and regulations and so forth, right? So it's given me a pretty good insight into the fact that our development permit guidelines are not clear, are not specific enough that I would feel comfortable turning it over to anyone else. And a good example, I think, would be the Tim Hortons on the corner of Bench and the Trans-Canada Highway. Now, if that had not gone to my wonderful advisory planning commission, we would have had an ugly little box with not very good landscaping and no community pathway and so forth. Like that was really important to get a development that people weren't so keen on having a box development right there, a fast food thing in Area E, but at least it blends in a little bit. So I'm thinking that this is more about timing as anything, and I think it's premature to us to be thinking about delegating some of these things. The soil deposit is a good example. Yeah, yes, we probably have to go along with the permits that come before us because it's a permit and they've checked all the boxes. But in the process, we've become quite knowledgeable about the frailties of that bylaw. So now we can go about fixing it. The other thing that I think that you would lose is if we don't know, if we don't have so much insight into the kinds of applications, then we aren't as sensitive as to your resourcing requirements when it comes to budgeting. So I personally think that the Land Use Services Department has been, we have not invested in land use services the way we should have for the last 10 years. And it has gotten us way behind the whatever the expression is. I think we're out of date and out of step with where the community needs to be on land use policies and regulations. And that was because we didn't invest in it. And now we're trying to catch up. And so understanding, for the directors to understand all this, it has been helpful. So I guess my comment is, I get where you're going. I appreciate it. I think it's premature. And when I see some of these things clarified in the modernization process, when we have good development permit guidelines and I can see that they're working because they come by and we easily approve them, then I would be willing to delegate. So that's my comment.
Okay, I have Director Salmon and Director Kuhn. Director Salmon.
Yeah, thank you. And thank you, Director Nicholson, for the uncharacteristically long speech with some good thoughtful comments. My question, I just want to ask Mr. Elf, so a lot of these delegated issues are technical and professional. Are we looking at any changes to the professional reliance practice that we have? I know we've had, various concerns from time to time about the quality of reports or the independence or lack thereof. So given that we'd be even less involvement or oversight of the technical reports, are we looking at any kind of a
Yes.
change?
So through the chair, yes. So I noted the development approval information bylaw. We do have that obviously in place, but that does also need to be reviewed and updated. And I would expect that our community planning division would be tasked with doing that. And the issue of professional reliance could somewhat be addressed through updates to the development approval information bylaw. As you know, in terms of our ability to require third-party professional reports or identifying particular professional that an applicant needs to retain to undertake studies on their behalf in conjunction with their application and so forth. So that's a separate piece of work that can happen. And it was certainly flagged through the provincial development approval procedures review project that has been ongoing, that is and continues to be an issue. But we're doing the best we can. You've heard me say that before.
I'm just wondering, would it make sense to get that work done first before we do this?
So the intent of the procedures bylaw is to address some of the deficiencies in the existing and challenges within the existing bylaws. Certainly delegation is a piece of that, and you can debate the merits of the existing delegation of authority, whether or not you want to expand that or decrease it. That's entirely up to you. But I mean, my recommendation going forward is that you continue to work on updating the procedures bylaw to address some of the challenges with the existing bylaw.
Okay, because conceivably we could leave the delegation piece off this and do the fees and the other Board of Variance, the other parts of it.
Yeah, I mean, delegation could be dealt. There is also a corporate delegation bylaw. So delegation for land use services currently sits within the development procedures bylaw. It could also be dealt with within the corporate delegation bylaw. And so you could either, like I said, you could leave what you have now, you could remove all of it. Bearing in mind that if you do that, you are going to see some longer agendas, and that's fine. We're happy to do that. It's just going to take longer. And I think the intent was to streamline and to make some things go quicker.
Thank you.
I have Director Kuhn and then Director Morrison. Director Kuhn, go ahead, please.
Yes, I just want to make a comment regarding a previous comment about the functioning of the planning department. I firmly believe that we have excellent planning staff. And if the majority or let's say, if the directors would just let the staff do what they want to do, we would be very well off. But we have a few directors that have taken an enormous amount of time, of staff time, for their own purposes, for their own areas, for their own little squabbles, and they're never satisfied with anything that comes before it. No, we have to do this, we have to do this. It all takes time. And there's two things that really trouble me about that. One is it makes our planning department look like they're inefficient, or they don't have enough staff, which we've gone through a tough time with the planning department, no doubt about that. But what bugs me is the time that is taken up by some of the individual board members is the time that is taken up of staff time that could be working on other applications. So it's a very selfish move for some of the directors to go and demand so many answers and so many squabbles with staff. And I've heard some pretty horrifying stories. And it goes all at the expense of the area directors that do just their normal work, and their applications get left behind because suddenly there's this enormous urgency about this particular thing. And I really, what I would like to do to especially to our ES world, that's the only members that on the board that deal with our planning department, to be a little bit more careful, be a little bit more considerate when we talk to staff, and have a little bit of faith in staff, because what I see now and then is a lot of criticism, and it comes at the board member, at the board level. The referrals I've seen going back to staff because, oh, we want this fixed, we want this. And yet, in many times, the report comes back and it's virtually unchanged. And then we vote for it. And I've seen it again and again, and it is so annoying. And I would really like to see that fixed. And I think that would take a lot of pressure off our staff. Thank you.
Director Morrison? And then I see that we've been another hour and a bit. I'm thinking that we're ready to close this Anyway, go ahead, Director Morrison.
Thank you, Madam Chair. And I was going to make a pun about the elephant in the Zoom, but I won't. This is important work that's being done, and I'm all for streamlining and speeding up the process of making efficiencies and all of that sort of stuff. But in review of a lot of it goes across not only the planning department, enforcement department. I'd like to ask Ms. Cheryl if there's anything in what's being recommended here that is going to have any impact whatsoever on the activities going on in riparian areas. And Director Salmon brought up the professional reliance model. And, as I said, I did a quick review of some of the applications that are that are in queue right now. And so many of them are riparian oriented. And those are the ones that have actually come in the door and are asking permission as opposed to forgiveness after the fact. Is there anything that you can say within your report and the initiatives that you're putting before us that's going to help to address some of those issues? Because this is general procedural stuff, but that's the biggest priority in my area is the degradation of foreshore and stream beds and removal of vegetation. It's the biggest area. So is this going to help us with that, or do we need to do something different to focus on the destruction that's going on in riparian areas?
Through the chair. So yes, if you want to focus on regulations to deal with impacts to riparian areas, you need to look at amendments to your zoning bylaw. So, or the introduction of the floodplain management bylaws, which will be coming forward. So those are the regulatory mechanisms to deal with development within riparian areas. It's not going to, amendments to the procedures bylaw are not going to change, whether or not there is impact on a riparian area. I mean, those things are still going to continue, and we'll continue to do enforcement on them. The only difference, if you want to rescind the delegation, is that we'll be bringing those applications to you, and you as a committee can then make recommendations to the board on them. So they'll it'll take longer to get the permits out for those ones that are asking for permission, but we can certainly do that. If you want to deal with impacts to riparian areas specifically, targeted enforcement, so increasing bylaw enforcement resources, amendments to zoning regulations, so increase your setbacks. Those are the mechanisms to deal with that.
Okay, thank you very much. Seeing no other hands up, that was for information. That was very helpful and very informative. We will turn now to question period. Ms. Harrison?
Yes, Madam Chair, thank you. We need to take a 10-minute recess so I can
course.
process the applications.
Okay, 10-minute recess. Thank you so much.
Thank you, Madam Chair. We are live. And
welcome back, everyone. Go ahead.
We have two participants waiting in the lobby. The first one up is Mr. Evans, and then the second speaker would be Ms. Kaufman.
Welcome, Mr. Evans. Go ahead, Mr. Evans. Welcome.
Thank you very much, Madam Chair. This was an excellent presentation this afternoon. Really, really good. I really enjoyed it. Question I have on the floodplain exemptions, could we get an example of a floodplain exemption? Like, would it be as big as a campground?
You'd have to ask staff on that one.
Oh, the staff still isn't here to answer the question?
Yeah, they can't. I'm sorry. It has to be to the chair if I could answer it, and I can't answer that.
Okay, well, you probably can't answer the other one either.
Uh-oh. Okay. Well, you
Thank
could
you
give
very-
it, you could, okay. I'm glad that you found it informative because we all did too. Go ahead, Ms. Kaufman.
Hello, Madam Chair.
Hello.
I too very much appreciated the presentation and the robust discussions. Thank you to Ms. Cheryl for her presentation. I have two questions, and I'm wondering if you can answer them as well.
Okay.
But I was a bit confused about the delegation of authority. I understood Ms. Cheryl to say once delegated, you can't take it back. But then I think I heard her say that you can review the delegated authority. Can you or Ms. Cheryl explain?
I can't explain that one, and she can't either. You can contact her personally, though. I did hear that as well, and I think I got it, but I don't want to repeat it back and get the wrong information. Oh, I'm not sure. And yeah, okay. Well, Ms. Cheryl is not allowed to speak. Because this is the public, it's the question period.
Yeah, this is very frustrating for the public when we sit through a presentation and then we can't answer.
I imagine it is.
The second question was, we heard a lot today about the shortcomings of the development permits. Do the staff ever do an internal review of an application to query such items as a professional role model, professional reliance model issues or outcomes that were not covered in the bylaw? This would be helpful in writing the new or improved DPs.
Could you repeat that?
Sure. We heard a lot today about the shortcomings of the current development permits. Do the staff ever conduct an internal review of an application to query items such as the professional reliance model issues or outcomes that were not covered in the bylaw? This would be helpful in writing new or improved DPs.
Well, that's within the scope of the legislation.
I'm not sure that
Well,
I understand that.
Okay, well, that's
legislation.
I could go back. It could be reviewed within the scope of the legislation.
Of the provincial legislation?
Yes.
Okay, because I understood that the CVRD was also looking at the professional reliance model and talking about a third party review.
I think there is a review going on with that as well.
Okay, thank you.
And then your first question, could you repeat your first question?
Sure. I was a bit confused about delegation of authority. I understood Ms. Cheryl to say, once delegated, you can't take it back. But then I think I heard her say that you can review delegated authority. And then I just asked if you or Ms. Cheryl could explain.
You can review delegations and change delegated authority by amending the procedures bylaw.
Thank you.
You're welcome.
That's it for me.
Okay, thank you very much.
Thank you.
Okay, thank you. I'm seeing that we now have a motion to adjourn. Motion to adjourn, moved. Second. All in favor? Opposed, if any? Thank you very much, everyone. Good night.
Enjoy your evening. Good night.
All right. Thanks, Larry.